very important, my lord, for the majoritarian group within the society and the minority group. Para 144 is critical, my lord, for my purposes. Neither of the above reasons also. That a minuscule fraction of the country's population constitutes LGBT, as observed, is not a sustainable basis to deny the right to privacy. The purpose of elevating certain rights to the stature of guaranteed fundamental rights is to insulate their exercise from the disdain of the majorities. This is what is happening to us. We are facing this disdain. We are facing this stigma. Whether legislative or popular, the guarantee of constitutional rights does not depend on their exercise being favorable regarded by majoritarian opinion. The test of popular acceptance does not furnish a valid basis to disregard rights which are conferred with the sanctity of constitutional protection. Discrete and insular minorities face grave dangers of discrimination for the simple reason that their views, beliefs, or way of life does not accord to the mainstream. I respectfully submit, Milan, this is the core of my argument. Because we are minuscule, because we have faced this over the years, because we have been sidetracked, because we are looked at with disdain, because we are looked at with unpopular feelings, because we are looked as squares. That's why the word queer. You are different, you are queer. And you were subjected to 377. You are no good. You are no good. That's how it was. That no good, my lord, is removed substantially by 377. But what about the stigma in place? As my lord Menka said, what about the stigma which is going on? In workplace, here, there, pension, we are facing that stigma. That can only be removed by a constitutional declaration by the highest court of the land. That my rights are equal to those of the others. They have a right of marriage, unit of family, respectability, plus a concomitant of rights which flow from that respectability. The same thing should accord to me. And I should not be discriminated only because, my lord, we may be 10,000 and the others may be 10 crores. This is the core, my lord, of my submission. Then, my lord, next page. Last line, my lord, of that page. I have to read this paragraph. Yet in a democratic constitution founded on the rule of law, their rights as sacred as those conferred on other citizens to protect their freedoms and liberties. Pausing here, my lord, it is argued on the other side. We are not equal. As if we are back in the 30s or 20s or 1800s, that you are lesser mortals. So don't talk about rights. Don't talk about marriage. Live the way you are. Be happy that 377 is gone and be done with it. That, my lord, is the approach of the majority which is being reflected by the other side. Sexual orientation is an essential attribute of privacy. Discrimination against an individual on the basis of sexual orientation is deeply offensive to the dignity and self-worth of the individual. Equality demands that sexual orientation of each individual society must be protected on an even platform. Very important, the phrase is even platform, not an uneven platform of equals and unequals. The right to privacy and protection of sexual orientation lies at the core of fundamental rights of 14, 15, and 21. There can be no doubt now, my lord, that my rights, which will ultimately now, this will be followed by Navtej. So reading this and Navtej will make it clear that the rights of all, including my clients, in full exercise and enjoyment of their rights in 14, 15, 16, 19, and 21 must be the same as that of the others. And therefore, the next logical step after removing 377 is the cherished object of marriage, family, and a unit in the society's order. And that, my lord, will give us other rights which we are talking about, whether larger issues, smaller issues, but those, my lord, will give us. But it gives us respectability. It's not only a case of, all right, no 377, but you live the way you want. Live the way you want in your house. Don't come outside. Because if you come outside, the majority will look at you with disdain. That has to be removed, my lord. And when your lordships do it, it has the same effect of law as Parliament by virtue of Article 141. And it is no answer ever to tell, my lord, a constitutional court, which is the guarantor of fundamental rights. My lord, last 70 years it has been said that this court is the guarantor of fundamental rights. It is no answer to say that even if one man comes and complains of his violation, my lord, of fundamental rights or an enforcement of fundamental rights, you better wait for parliament. No answer. No court has, this court has never accepted that answer. 32 is itself a fundamental right. I have a right to come to the court and complain. My fundamental right is being violated, not followed, not being implemented. And this court must come to my aid. Need not be a group. Maybe the whole, my lord, the population may be against me, but I have that right. And I cannot be told, with great respect, I submit, my lord, in humility, that I must wait for parliament. Somebody should then enact after I am dead and gone. Then, my lord, 145. When your lordship, my lord, reverse Kaushal, last 4 lines, my lord, of 145. The rights are not so called, but are real rights founded on sound constitutional doctrine. They inhere in the right to life. Again, 21. They dwell in privacy and dignity. Now a part of 21, my lord. They constitute the essence of liberty and freedom. Sexual orientation is an essential component of identity. Equal protection demands protection of identity. So real rights, that people should not look at me with disdain. People should not say you are queer. People should not say let's not be friends with you. Then, my lord, that is Kaushal. My lord, 146. The decision in Kaushal presents a de minimis rationale when it asserts that they have only 200 prosecutions. This is that argument of minuscule against the majority. Kaushal went on this, my lord. So very small people, very small group. How does it matter? Why should it bother? The de minimis hypothesis is misplaced because the invasion of a fundamental right is not rendered tolerable when few are opposed to large number of people. This is the minority versus the majoritarian rule. No steamrolling. No steamrolling of ideas, faiths of one major group over, my lord, a small. Otherwise, my lord, look at religion. It will lead to religious persecutions. Suppose in a country, my lord, the majority is of one religion and you have small other religions. If you go by majority, you will steamroll the other religions. The moment you do that, you lose being secular. You lose, my lord, being plural. So our constitution has guarded against it. Be diverse, yet be Indian. Be whatever religion you have, but you are an Indian. Whatever faith you profess, whatever language you speak, no matter your card or your creed or your caste or your place of birth. The constitution intends to raise all this, my lord, from the times of 1800s and the deprived to today to be a forward-looking, my lord, community. Yes. My lord, second line, placidum G. The concept is founded on the autonomy of the individual. The ability of an individual to make choices lies at the core of human personality. Choice, notion of privacy enables the individual to assert and control the human element, which is inseparable from personality of the individual. The inviolable nature of human personality is manifested in the ability to make decisions on matters intimate to human life. These words echo today. Choice, my lord, of human lives, choice of people. It's not, my lord, an elitist concept. It is, my lord, innate, with which people are born. So was Nero born, and thousands of years ago. Autonomy of the individual is associated over matters.
On Nero.
Sorry, my lord.
Let's not model ourselves. Sure.
You're right, my lord. You're perfectly right. We can't model ourselves on Nero.
Of all the
Nero said this when Rome is.
There are enough examples.
He was saying that
We
when
can't-
Rome was burning.
I say we can't fiddle.
Yeah. Then, my lord, between placidum A and B at page 560 of the report, without the ability to make choices, the inviolability of the personality will be in doubt. One line later. Privacy is a postulate of human dignity. Thoughts and behavioral patterns which are intimate to individuals entitled to a zone of privacy where one is free of societal expectations. In that zone, an individual is not judged by others. Privacy enables each individual to take crucial decisions which find expression in human personality. It enables individuals to preserve their belief, thought, expression, ideology, preferences, choices against, please mark, my lord, very critical, against societal demands of homogeneity. So no steamrolling. Privacy is an intrinsic recognition of heterogeneity or the right of the individual to be different and to stand against the tide of conformity in creating a zone of solitude. Privacy protects the individual from the searching glare of publicity in matters which are personal. Privacy attaches the person not to the place where it is. Privacy constitutes foundation of all liberty because in privacy, an individual can decide how liberty is best exercised, etc., etc. So this is the tide of the majority which is stigmatizing me, my lord. Today it can't criminalize me because of a lordship judgment. It can't criminalize me like Mr. Thomas was criminalized, my lord, in America. When the police came and knocked on the door, it was a police raid. They found, my lord, he was indulging in that act. And he was charged by University of that law of Texas. I can't be criminalized, but the stigmatization continues. My lord, last 10 lines of that page in para 298. The autonomy of the individual is the ability to make decisions on vital matters of concern to life. Privacy has not been couched as an independent fundamental right, but that does not detract from the constitutional protection afforded to it. Once the true nature of privacy in relation with those fundamental rights which are expressly protected and understood. Privacy lies across the spectrum. The guarantee of equality is a guarantee against arbitrary action. It prevents the state from discriminating between individuals. The destruction by the state of a sanctified personal space, whether the body or mind, is violated the guarantee against arbitrary action. Privacy of the body entails individual to the integrity of the physical aspects of it. The intersection between one's mental and integrity and privacy entitled the individual to freedom of thought, freedom to believe in what is right, what is wrong, etc., etc. Milord, just between placetums B and C, the freedom under 19 can be fulfilled where the individual is entitled to decide upon his or her preferences. Read in conjunction with 21, liberty enables the individual to have a choice of preferences, etc., etc. Sorry, I missed one line. See the third line on top. Family, marriage, procreation, and sexual orientation are a part of dignity, and dignity is a part of 21. So what I am requesting your lordship to grant me a declaration is a declaration of my right under 21. That's what I am respectfully submitting. And procreation in Milord today's scenario can also include adoption, IVF, surrogacy. Need not only be procreation in one form.
I think family comprehends it.
Yes. Then Milord again, I have read that lesson. Now Milord 299, first line. Privacy represents the core of human personality. So privacy, dignity to lead a full life, full enjoyment, sits in Article 21. And therefore, my lord, my request to the court is a declaration of my right under 21, read with 19 and the troika of 14, 15 and 16.